May I please your lordship? Lordship, I would like to mention for listing of an interlocutory application, my lord, in criminal appeal number 256 of 2020.
Interlocutory application for what?
Interlocutory application for bail matter. For bail matter.
Next week.
Deeply obliged.
Medical report was also as because health condition and acute here he was hospitalized from 19/1/2024 to 28/1. As her health condition was very much deteriorated, since then she has been following medication as per advice of civil Dr. Haflong. She is suffering from type 2 diabetes mellitus with moderate fatty liver with left renal calculi as per report received from medical officer. Certificate of doctor is there. It's my doctor report. Jail superintendent verbally informed me for daily that her condition is observed to be not good. She has been deteriorating day by day because of the diabetes. And your lordship, because of the poor economic condition, cannot take the healthy food as is required to have for diabetic patient, my lord. Our son is somehow managing by riding auto, somehow managing and because in the jail it is not possible to give diabetic food to the lordship convicts or inmates of the jail. But as per observation of the jail authorities, our condition is deteriorating, but they don't have any in-house doctor. And as such, inmates are referred to Haflong Civil. This is off the record, my lord. But your lord, certificate doesn't say so, my lord.
All those reports are of January.
Yes. Sir.
Right. Certificate is of
Latest.
It is.
27.
But this certificate is based on report of January.
Lordship, may I be permitted?
With medical report.
Yes.
On the basis of recent laboratory report.
Lordship, yes, she may be allowed to have the taste and all, and thereafter report is submitted.
It- it- Madam, you get a copy.
I have already, Lordship, on
There
her
is
verbal
none
prayer
of the
court
draft,
directed,
huh?
on her verbal prayer court directed. For the
Hello. Observe. Because there is no such draft in the application regarding medical.
Recently, we have received the information that the health has been deteriorating. Earlier, we have not received that.
Right.
Your Lordship, one more
As
prayer.
Nazin and it comes for the applicant. As Ipnia land in the constitutional law. It's fine. Yes,
Our task.
hard. Land it comes for the yes. One more. It- any other. When its submission was made, the previous 23 report on behalf of the applicant, the health condition of the applicant had deteriorated, comma, and additional public prosecution was requested to obtain a report as regards the present health condition of the applicant from concerned health superintendent, comma, district health superintendent, day, comma, yeah, has faced a communication dated number 29/4/2020, comma, attached by the superintendent of the, comma, enclosing therewith a report of the medical and health officer as one, comma, from medical officer and other connected medical from the document annexed to to the state to the communication dated 29/4/2000. It appears that the applicant has been suffering from type 2 diabetes mellitus with moderate fatty liver with left renal calculus. It has been reported that the applicant was admitted in a Haplong Civil Hospital on 19/1/2024, and after improved medical condition, was discharged from the Haplong Civil Hospital on 21/8/2000. The medical laboratory report annexed with the discharge certificate of the Haplong Civil Hospital support the state. The health status report of the medical and health officer from Haplong Civil Hospital. It is not known whether the health status report of the applicant given by the medical officer is based on recent medical laboratory report or not, or whether the said report is based on the medical laboratory report given in January 2000 to consider the matter of the present health condition. Comma, fear of the considered future. For concern the jail superintendent, sub jail, Haplong, shall submit a report. Submit a report as regards the health condition of the applicant from the medical and one medical and health one Haplong Civil Hospital based on recent medical laboratory reports. It has been said by the superintendent of jail that there is no permanent medical and health officer in sub jail from Haplong, and the jail inmates are required to be sent to the civil hospital Haplong for their medical treatment, as and when need arises. I mean, from same town, how much time will you get? Madam, you file a proper, give some nothing in your application
regarding the
regarding
medical information due to that
it is up to you. I don't
we will find
observe
another
anything.
we find I regarding the medical condition you are
It is up to you. Not here.
raised
MS Mia shall obtain report as regards the current health condition of the applicant in terms of the observation made above. Place the case on 8th of May.
as per order dated 8/1/24, Your Lordship, there was no order is regarding the issue of notice upon respond number 2, Your Lordship. We will take steps upon respond number 2, Your Lordship.
This is 302.
Oblige.
Maybe. It's a criminal appeal. There is a delay in filing. Delay 16 days. In
Yes.
filing.
16 days.
Yes.
16 1.
On 6.
Respecting the court.
Part A. It appeared the delay of 16, which is occurred in preparing the cutting pen. The connected has acted, has been the judgment and order
22 on.
25 against the judgment dated 21
22.
2000 and an order of dated 25 2021 by the Senate Special Judge Walper in Special Interest case number 70,000 by the judgment dated 21,020. The accused found guilty of offense.
Lord. My senior is on leg in court number 26, Lord.
Huh?
My senior, Mr. Saket also is on leg in court number 26, Lord.
We have this one only.
Yes, Lord. My
There is no other matter.
They have done their part. The kidnapping for ransom.
They have done their part.
yes, Lord. Already our evidence part already done.
Some on the
My senior will come, sir. After.
Lordship, I would like to rely on the evidence of two witnesses. One is Dulal Nayak and one is PW5 Amit Nayak, who is the victim. PW1 is the father of the victim.
you want to die on evidence of
PW1 and PW5.
PW1. Father,
Yes.
Okay.
Radial of
and PW
5.
Victim.
Victim. PW1 and phase 12. My name is, the name of my son is Amit Nayak. The incident took place on 9/5/2010. He was aged about 15 years then. Lordship will kindly notice this. The age of the victim is 15 years. He was reading in class 10. The incident took place at about 11:30 a.m. that day. That day, my son went to Business Shishu Kalyan High School. He went to the school alone on the occasion of Rabindra Jayanti. When I was heading home, I came across him on the road. Since my son did not return home till evening, we asked his friends about him. He did not return that day. A boy said that he had seen my son at Anamika studio, Disney, and a Tapash alias Baba was along with him. I don't remember who told me that. When I went to Anamika studio on the following day, the owner of the studio, Harlal Rai, told me that my son had gone to his studio with Tapas. Tapas' house is situated near my house. I went to Tapas' house, and when I asked Tapas, he told me that he and my son had left each other in the market. Then, first I verbally informed the PS of the incident, and thereafter I lodged an Azahar with the PS. Exhibit 1 is the Azahar, and Exhibit 1-1 is my signature therein. Around 7 p.m. on 10/5/2010, someone made a phone call to me from the mobile phone on 961-3635-121 and told me over phone that they were terrorists, that they had kidnapped my son, and while demanding rupees 1 crore for the release of my son, the person said that they would send the dead body of my son to me if the demanded money was not given to them. I told my friend Narayan Sarkar about it. Narayan went to the PS, taking my mobile phone with him, told police about the matter and showed the mobile phone to them. 2 days later, another phone call was made to me from the state mobile phone number, and on that occasion, an amount of rupees 95 lakhs was demanded. On 13/5/2010, I was informed over a phone call made from Business PS that my son had been recovered. When I asked my son, he told me that Tapas had taken him away and handed it over to Sanjay, Mahadev, and Dipankar. Exhibit 2 is a statement recorded under Section 164 CRPC. I am not aware as to whom the mobile phone number I have mentioned above belonged to. Accused Tapas Malik was a friend of my son, and classes and schools they read in were different. Accused Mahadev hails from my locality. I am acquainted with him. While talking with me over phone, they did not mention that they were terrorists. They talked to me in Assamese. After receipt of phone call on 10/5/2010, I did not lodge a written SR with the PS. My son went to Harlal studio to load song. Harlal told me that another boy went to his studio with my son. Narayan went to the PS taking my mobile phone with him and reported the incident to police. Police did not seize that mobile. I'm aged about 44 years and I don't have property worth rupees 1 crore. I lost and returned Azahar with a PS on 10th day of month. I lost Exhibit 1 Azahar after the recovery of my son on 13th day of month. I don't know from whose house, under what circumstances, and how police recovered my son. It is not a fact that the accused person did not kidnap my son, that he went to visit some place that police recovered him. I made my statement under 164 CRPC in the court. 1 or 2 days after the recovery of my son, I studied Bengali. Lordship, there are said to be two FIRs, my lord. One GD entry and one which is lodged in 13.5. But lordship, I may be wrong. I could not find the 10.5 GD entry. Entry was made, but FIR I didn't get. 10.5 FIR.
What is the content? What is the content?
And
See, after the investigation was
initiate, my lord.
this FIR was lost after recovery of the
13.5 FIR. Yes.
alleged kidnap.
Right.
So what will be the consequence? What will be
Lordship,
the
that
effect?
effect, my lord, first FIR, the GD entry
See,
will be treated as
By
an
the time
FIR.
FIR is lost, all the is for were incorporated.
I know.
Five.
Yes.
In the FIR. That is after recovery of the boy from a house wherein the other three of the accused persons were present. So, with that allegation, the FIR was because in one of the accused house, the boy was found. And there were the other. So, it was after recovery of the boy. It was not, this FIR was not prior to
Yes, my lord.
investigation resulted into recovery.
My lord.
Thereafter,
Right.
so whether what kind of this report is treated as the FIR or
Previous report, GD entry. It may be, it,
treated as the
lordship, I have restart. Yeah.
who is the IO?
IO is PW 11, my lord. He talks about the GD entry 244, dated 10/5. PW 11. GD number 240.
244.
Then Narayan, later on,
But
they'll
remember
might have not
correctly,
had it is the court process. Shown as exhibit.
no, that was not exhibited. But GDNT has been
Then
exhibited.
uh-huh.
Took the mobile where the alleged phone call was received, demanding ransom.
That brother,
He,
Narayan.
no, his friend, father's friend.
Yeah, yes.
father's friend, he deposited the mobile. Where it the
No, Lordship,
uh,
Narayan went to PS taking my mobile phone with
right.
him and reported the incident to police. Police did not seize
That
that
is
mobile.
that is their problem. So we want to know how this has happened. Because see, on the basis of that, they collected the CDR, right? Thereafter, uh, people were kept under surveillance. So that amount to an investigation.
Yes.
Though the CDNT is not disclosing any cognizable offense, it discloses that the boy was, but the other information they have given while depositing the mobile or whatever,
Doesn't say.
no, that somebody has demanded ransom.
No, that
Whether
entry book
those
doesn't say so much. Maybe
Okay.
other day I have read the contents that
so CDNT says there is a decent report.
even the IO says so.
We take that because that general register is here. We take the other end.
Other end, 40.
Because was going on. People were kept under surveillance. CDR reports were collected. Thereafter, SDPO made a report. He also says on Monday, 10/5/2010, an Azahar regarding of the sun was submitted to the visit at around 7:50 p.m. in the evening. Some unknown people gave phone calls from cell number. Miscreants demanded a ransom of rupees 1, telling which they would kill the son. So on 10, police received the information regarding commission of a cognizable offense. Right. Police oral, they were quite aware that there was commission of a cognizable offense on 10/5. There are entries of 10-5, but there was nothing regarding deposit of mobile.
Call.
For phone call, nothing ransom. There was nothing in the what to have been there because that GTNT 244 was registered at 12 of noon, 12 o'clock
10-5.
on 10, and even in the evening, there was a phone call demanding ransom. And thereafter, his father and not his friend went to the police station, depositing a mobile phone, and this is a mobile phone when it a call for demand for ransom was received. But it also said that police did not seize mobile. There was not even GD entry also. IO is not saying anything
Regarding
regarding deposit of mobile or anything. They
No.
said,
Then I made a request to SDPO for collecting CDR of the state mobile phone number. It was
Huh?
found on a CDR that a state phone call is superintendent name of the SIM card holder Arun Singh.
the investigating informant appeared. Informant appeared in the police station and verbally informed at about 7:50 p.m. on 10
Right.
5 2010. He had received a phone call over his mobile from mobile number so and so, and that the caller had demanded a ransom of rupees 1 crore for release of his.
Lordship,
IO is saying, but
Lordship that 244 GD timing.
I have said 12 o'clock noon.
Then this is 7:50 p.m.
There was no GD entry. On the basis of what? Memory, he's saying. It should have been state from the general diary entry. Then I made a request to the SC.
May I see the case that if they have taken
Yes.
mistakes?
For this, for A.
And-
Then is quite stringent. That's why I'm looking at Porano.
Noon, 12 noon. Laura Herua Dorot. But the seizing of the mobile,
So that we have to exactly that. Otherwise, a glance at that GTN 244 that talks about missing.
is
That does not disclose any cognizable offense, right? But written report was there. That is not exhibit. Everybody is saying that there was a written report on the basis of which the general diary entry 244 was registered, right? Then it appears when the mobile phone was taken to the police station at about 7 PM on 10/5/2020 that there was a demand call made from some phone number, this phone number to this mobile. Okay. Now the person who took the mobile phone to the police station, he says that mobile was not seized. But from the IO's statement, it appears that he says that without any GD&T, how he remembers, I don't know.
Yeah.
Right? But he
Timing
said,
also is
but
very,
he said, thereafter he made a request to the SDPO for collection of CDR, call
CDR.
detail report,
Right.
of the said mobile.
Right.
And it was found from the CDR that the said phone call came from Bishnupur area. And the name of the SIM card holder is Arun Singh. And the place was Tikajpara. I got secret information from Bishnupur area that two boys had taken shelter in a house and that they did not come out of that house. We went to the house of the Arun Singh, asked for a mobile phone. He said, so investigation was going on. Thereafter, after this ransom call, investigation into a cognizable offense took. In that background, what will be the FIR? What will be its effect of the FIR? What happened?
Lordship, first GD&T was made, my lord, on the basis of the investigation progress. Call details were recorded, but no certificate have been, my lord. That part will, submission will go. My lord. So, my lord, other part will remain the version of PW1 and PW5. Whether it constitute a commission of 364A.
Even there are two things. The actual happening should be based analyzed from the whatever has fallen from alleged
Victim.
right? What he said,
Lordship.
PW come to base 20. Let's 6, 7. Thereafter, we got our hair
Yes.
dressed in a salon. At that time, Tapos was there. Right?
Yes.
There from Tapos only took me to Satyan. Okay. So whatever kidnapping or whatever would have taken place from Satyan,
Satyan.
right? There was jungle near it. Here I came across Mahadev Das.
Dipankar Mallik.
Then Deepankar Mallik took my bicycle and left for purchase of business. After Deepankar came back with the bicycle, Deepankar took me to the jungle.
My lord.
There Mahadev, Deepankar and Sanjay asked us to travel to accompany them. When I asked why I should go with them, Mahadev and others said they would demand a amount of rupees 1 crore from my family for my release. After keeping me in the jungle during day, Mahadev took me in the evening by bicycle to the house of Piyush Goenz Ram Prasad in the village at Bishnupur. Mahadev demanded an amount of rupees 1 crore from me. Right?
Right.
Over a phone call made from mobile phone. I talked to my father. He also talked. I stayed at night in the house of Ram Prasad. The following day, I was again taken possession. Now, question is, in the context of this 54A, that only demand will not fulfill the ingredient. There should be what? Apprehension.
The mind of
In the mind. He never said. He talked to his father. He talked to his father. And Mahadev also, he
Right.
demanded But there was nothing from in his evidence that there will be hard to be caused, death would be caused, or by his conduct give rise to a reasonable apprehension that such person, Amit, may be put to death or hurt. Because he was also talking with his father.
Yeah.
And the father did not say, my boy talked to him. So, the kidnapped boy
Right.
have never said that he was put to apprehension that heart would be caused or
Lordship,
death would be caused. Where is it?
Page 30, last line. When I asked my son, he told me that, or maybe after recovery.
All these are hearsay, madam. After the boy was recovered, story took a different kind. We are not into, so far as post recovery is concerned. If somebody says, after hearing from the kidnapped boy, everything falls into the category of hearsay. Right? Because they have exaggerated the version. You see, for example, take anyone, say mother, let us take the example of mother.
Mother PW2.
Mother. What did he say? Gross PW 2,
PW2,
2 or 3,
my lord, page
Two.
17.
2. Last line. Today I have adduced evidence in the court upon hearing about the incident from my son. Everything he said after hearing from our son. Somebody exaggerated, some put dagger, some put. All
Lordship,
these are after recovery,
After
after hearing the
after-
story
Yes, of
from the boy.
PW5.
Boy never said. Dagger was put, knife
Lordship,
was
may I
put.
take your lordship 164 statement of the boy also? Page 91. It will corroborate. But he talks about page 91.
Which part?
Lordship, page 92. Thereafter, Mahadev pulled out a dagger from his body and told me that if I raise Halla, he will kill me. And in the meantime, Dipankar and Sanjay also came up with daggers and threatened me if I raise Halla, then they will kill me. And on that day, I was kept in his jungle, and in the night, they took me towards north and kept me in a house. Next day, after spending therein, I was taken to another house, and whole day we spent there. And in the evening, Mahadev brought one mobile from the state household and called to my father's house and demanded rupees 1 crore. On that night, we stayed in that house till 12:15 a.m. and returned to the house where earlier night spent. On next day, I was taken to Bishnupur forest, and after spending 6-7 hours there, we again came back to home where we spent first night due to fear of elephant and stayed in the sick house.
Because he was
Lordship
not
is 93 also.
kept tight anywhere. Yes.
During my captivity, the boys threatened me that if their demand not fulfilled, they will blow away our home with bomb. While at the time of calling of my father, they put on the speaker, I have to say only when I was dictated by them.
Whether they can be treated as an evidence.
Not an evidence, 164, but it will corroborate, not a substantive evidence.
Whether the purpose of
164
what it do. How it
for the purpose of corroboration.
what prevails is the testimony made before the court. And what is the evidence? This is not evidence.
Evidence is,
Evidence.
yes, my lord, whatever is stated before the court of court.
Then which one will prevail?
The,
Put the
if it-
dagger, the story about him putting a dagger by this,
that is not there.
or
That is not there.
Ah.
In substantive evidence.
not putting a dagger when he testified before the court. Which one will prevail?
Whatever he has testified before the,
The defense did not
but lordship,
do
there may be,
not to cross-examine him, because that is not a
lordship, may I submit, as the, why the evidence of the victim's boy should be disbelieved, my lord?
Oh. we're not this big.
No, regarding the threatening part and all,
No, where is that? That is what I am asking. See, madam,
no, lordship,
Uh,
not there. Only they say that they are terrorists, that they had
Who?
them by One.
PW5, read
PW1.
again.
PW
Whether he said that in his testimony before the court that I was put to threat, I was put into apprehension, that if I don't support them,
Well-
I will be killed. Nothing.
No, from him it doesn't come.
He said Mahadev called in his presence. His father demanded 1 crore. Okay. Okay. But it has to be accompanied by a threat.
Lordship,
Threat,
where-
right? This is the ingredients of the offense.
my lord, may I submit there,
Otherwise, it may amount to mere kidnapping.
lordship?
Demand has to be, and there has to be a reasonable apprehension
Yes.
on the mind of the other person that such person who was allegedly kidnapped, harm will be caused to him or death will be caused. Right? So far, boy is not saying that demand was with a threat that in the event 1 crore was not given, even boy will be killed. Right? Boy is from the
Boy
evidence, it
doesn't
is
say
not
so.
emerging. Now the father.
The
Now,
father,
when the first person's statement is not telling with the second person,
no, I meant to say,
yes, tell
because the victim was in captivity, so like, it doesn't come
no,
up
no,
with
he
the-
testified when he is totally free. Madam,
No, lordship, no, he was in captivity, so it was, may not be known to him, whatever the call, the contents of the call made by the kidnappers to his father. Because
no, where is
all
that?
along
He
they
was put to threat.
no, it was not, it hasn't come from
Madam,
him,
364A.
lordship.
You have to make something in the context of the ingredients
Yes.
required to be fulfilled for attracting his.
Whoever kidnaps or abducts any person or keeps a person in detention after such kidnapping,
This is one part.
yes, or abduction and threatens to cause death or harm to such person, or by his conduct gives rise a reasonable apprehension that such person may be put to death or hurt, or causes hurt or death to such person in order to compel the government or any foreign state or international intergovernmental so to do or abstain from doing any act or to pay a ransom shall be punishable with death or imprisonment for life and shall also
Now, so far, causes heart. Let us go to the medical. 98.
PW10.
98. Medical examination was done.
I know.
Finding pain on abdomen.
Please name.
There was no injury mark on the body. The injury was simple and was caused by blunt weapon. His conclusion. Now let us see his evidence. Doctor, page 39.
Lordship is there.
39.
Injury was simple in nature caused by blunt object.
Very cross.
I did not advise ESD to detect a cause of pain. There was no external injury mark at the abdomen of the victim. But regarding weapon,
Pain at abdomen may be due to gastritis or any other
other
disease
disease.
also. I did not advise ultrasound to detect the cause of pain. At abdomen. There was no external
External
injury mark at the
abdomen.
abdomen of the victim. No heart. No heart.
no, there was no external injury mark. The injury is simple in nature, caused by blunt. Injury mark is not there.
Injury is simple caused by blunt of. Now what he said?
There was
I did
no
not. There was no external injury mark
injury mark
at
at
the
the abdomen.
abdomen of the victim. How could he find injury mark there? All these are when crossed. He said pain at the abdomen may be due to gastritis or any other pain in abdomen. No injury. No, he never said. Doctor did not say. Heart was no. He could not find any external mark. Gastric. Yes, the boy was there. The mom. What are the ingredients? He is not saying that he was certain
Lordship.
that heart would be caused. Demand, yes, he said about it. We agree.
Right.
Where is the corresponding threat?
If you
Recently, he was recovered. He was trying to extort money from his own
Got
family.
that's the reality of it.
Right.
At the
There are
judgment of
There are
2024,
incidents.
my lord,
Recently, you
lordship,
go to last 7 days paper.
my lord.
Who is a brother of a legislator. He got himself kidnapped. Made a demand call with the association of companies. After police raiding him, covered him. And he everything came here that he got himself kidnapped to get some money. Now, what is the story then?
Then the lordship, if your lordship holds
He,
that the 364 it doesn't
now
attract,
see the mobile phone that is connected, right? Keep aside.
CDR and all.
So far from the boys, and he did not say anything about it. That heart would be caused to him
Right.
or death would be caused. There was no threat. As per his testimony, father said that by the ransom call, he was put into an apprehension that the boy would be killed. Now, to establish that phone call,
So
65
lordship,
B,
that is not there. So the other
you
part will
did
remain.
not seize the mobile for whatever reason, despite handing over the mobile by the
Person.
father,
Friend of the
you
friend.
did not seize, you did not record any.
the call
The
details were
DDS
recorded. The 65P, it was exhibited, no? CDR. But 65P certificate is not there. 65. Yes, it's there.
So what the patent
No.
and the primary evidence was not ever, the mobile would have been the primary
Yes,
evidence,
yes.
primary document
Lordship.
that was not there. You did not see according to IO. So how the other thing is connected? If you read William Stephen,
Yes. That is, I'm carrying those in your paper.
yes, then how do you connect?
Lordship at 363 would be attracted. I think
So
they are
then
behind
we'll
the
come
bars.
to, then we'll come to that.
Yes.
Then we'll come to that.
If other part goes, then 363 would
Now
remain.
we'll-
Because lordship is of the victim.
Now we'll see.
Yes.
Now we'll see.
Administrative appeal,
361
Lordship,
to punish them
Right.
there. in the queue.
my lord.
361, ingredients of 361 are required to be fulfilled.
Right.
Now, what is enticement?
Lordship, dictionary when you have.
Huh? See, he was moving on the Rabindra Jayanti day. He went to the school, made tapas on the way. Then they decided to download song, went to the studio. Thereafter, they came out of the studio because there was no electricity. But download the song. And thereafter, they went to a
salon.
salon, got their hair straight. Then they went to a place. Till that time, there was no role of these
Kidnappers.
were they made it a public place, Satyanpuri or something. Thereafter, they went inside the jungle.
Jungle.
Before that, Bitilnath, cycle, all this.
All the
And went inside the jungle. He was not tied by rope. He was moving around with them inside the jungle. Then he was taken to. There is no whisper that he made me more
to free from the
captive. It was not evident that he was captive. He was not tied. He was not confined inside
confined inside a room.
in a house.
Yes.
He was kept in a house.
Yes.
Kept and confined is a different.
Different.
Confinement, wrongful confinement will be an offense. But he's not saying anything. That was right. Because the carpet was there. It's put there. Now, this kind of conduct,
It will attract even
the
361.
conduct of the LA's scheme, as well as the conduct of the LA's kidnapper, would indicate an act of kidnapping. Evidently, we admit he is 15. The threshold is 16. In case the minor is a boy, he is 15. Let us assume for whether this kind of conduct enticement appears to be but
Mere reading of the meaning may not attract.
what
And
is
Lordship, I
meaning?
think they are Asam
And see these are known. This boy, they neighbor. Another one is neighbor.
some of them are not known.
Two of them are known.
Yes.
There are many incidents in our life where five boys were there. Two of them are known. We have gone there.
Yes.
Had something in a restaurant.
True.
Had gone to a cinema. Is
And
known.
at this age, while it happens, 9 plus 10,
Is keeping. Now this is taking out or enticing from the lawful guardian's court. Yes. It's not there that if he do not go, if he, suppose he does not accompany them, then thing like yes, you do not accompany us to inside the jungle, you'll be harmed. There is nothing like
nothing.
but to for instance, The word entice seems to involve the idea of inducement or allurement by giving rise to hope or desire in the other. No hope,
Nothing
here,
on record.
no hope was there. No desire was given to him.
Although it might be their secret, something, my lord, they have some
They may
better
have
plans,
planned it,
better plans.
but he is not disclosing.
No.
And he is not small enough, like 7, 8 years, 15 years. Sitting in class 9 or 10.
17 years at the time of
Giving it.
substantive evidence, date of occurrence 15 years.
So he was 17 at the time of testimony. Otherwise, they at the time of testimony he was 15. So he was not given any allurement or that, oh, something would be there.
Okay.
He, he will be able to kill a deer.
I know.
That will not, you can hunt a deer. You go inside. But there is no such kind of allurement given to him as per his own testimony.
Gotcha.
So,
Can it be 360?
how
Whoever kidnaps or abducts any person with intent to cause that person to be secretly and wrongfully confined shall be punished. with-
364 is not there because the boy himself is saying that it was never.
365.
Million.
It will in a case reported in 2004, it assessed in 95, it was converted to 365. Converted to 360.
So what is the fact? Confinement. That requires confinement.
Here it has been observed, my lord, because demand cannot be made to the victim. Although the 364A says so, the demand has to be made to the victim concerned, my lordship. Whoever kidnaps or abducts any person or keeps the person in detention after such kidnap, but there are two parts. One to the person concerned and one to somebody else.
Yes. But one is putting that person on debt. And somebody has to be informed that you do not comply with this thing. The person who is in confinement will be harmed either by causing it.
Okay.
But that element, as
Right.
per William,
I know.
suppose with regard to the phone call to the father, that's not cancer. So that it might not be there.
I know.
If it is, suppose this is not there, we have to come to the minor one.
Right.
361, one is by 360. Whether those, one is lawful guardianship, second is 361,
Okay. Yes.
and second is enticing away or taking away. If he is not a minor, it been a major, would have been say abduct simply.
Right.
And abduction simpliciter is not fine.
I know. Lordship, but
Now we are
365 says any person.
But for 365, we have fulfilled 361.
Right.
And we will travel to 365.
Lordship, because the He was not kidnapped from the lawful guardianship. And he was go.
He's to attract 365.
Yes.
To punish him. First, 361 is to be fulfilled. If 361 ingredients are not there, suppose, how can you?
Lordship, 365 says whoever kidnaps or abducts. Lordship, if your lordship holds he is a minor, then it will be kidnapping.
And
Then that-
361
Yes.
to be there. Will be inherent. That lawful guard. Now, whether this kind of contact, whether I even unfolded, whether this is taking away or enticing away a minor 15 years from the lawful.
I, it may not.
My lord, if your lordship permits, one more submission.
But
With regard
Whoever
to,
is there,
so they take this William
I know.
because they were punished under the minor. You read from that part.
Para 5, my lord.
Para 5. It's the story.
My lord.
Submission. Para 5. Para 10.
Para 10.
The first ingredients.
Yes.
Ah.
The first ingredient of section 364A is that there should be kidnapping or abduction of any person, or a person should be kept in detention after such kidnapping or abduction. If the state act is coupled with a threat to cause death or hurt to such person, an offense under section 364 is attracted. If the first act of kidnapping or abduction of a person or keeping him in detention after such kidnapping is coupled with such conduct of the person, kidnapping which give rise to a reasonable apprehension that a kidnapped or abducted person may be put to death or hurt, still section 364A will be attracted. In the light of this legal position, now we refer to the evidence of the child PW2. We have carefully perused the evidence of child PW2, who is the victim of the offense. At a relevant time, the age of the child was 8 years. In the examination in chief, he has given vivid account of what exactly transpired at the time of the incident. He stated thus: I had been getting back home around 7 o'clock at night after attending the tuition as usual. A swift car is grey shade, bearing registration number so-and-so, gave a halt by my side. There were 2 persons on board. They summoned me, stating that my father is going to buy a car. They took me on board. They sought the phone number of my father. I gave them my father's phone number. They asked my mother's number. I gave them my mother's phone number. Subsequently, I fell asleep in the car. When I got up in the morning, I found the car in a check post. The police got them nabbed. The person who took me in the car as such are the accused who are present before this court. The car is marked as MO1. The police questioned me. I have recounted a turn of events. We have carefully perused the cross-examination. On the main incident, his version has not been shaken in the cross-examination. It is true that in response to the questions put to him in the cross-examination by the advocate appearing for the accused number 2, the child PW2 deposed that his father PW1 taught him the particulars which need to be reproduced in the court, and that he has recounted the particulars taught by his father before the court. We find from the cross-examination of the child PW2 that there is hardly any challenge to the main incident. In fact, a suggestion was given to him that the man who had taken him in the car Arda, ones who were acquaintance with him and his father. This is the defense as reflected from the cross-examination. It is not brought on record by the accused that there was a prior enmity or animosity between the parents of the victim child and the accused. There was no reason for the father of the victim to falsely implicate the appellant, and tutored a child to depose against them. Therefore, the case sought to be made out the child was tutored by his father was not rightly accepted by the court below. Therefore, it can be said that a kidnapping within the meaning of Section 361 of the Indian Penal Code was established by the prosecution. Hence, the appellants are guilty of the offence punishable under 360 of the Indian Penal Code. The learned senior counsel appearing for the appellants were at pains to point out inconsistent verses of PW1 and PW3 about who received a phone call demanding ransom. However, this issue need not detain us. The details of the phone call records were produced by the police. It is an admitted position that the police could not trace the name of the person who was holding the cell phone number stated by both the PW1 and PW3 in their examination chief. The version is that they received a call demanding ransom from the state number. The record relating to the call details has been discarded by the High Court, and there was no certification under Section 65B of the Evidence Act. The call records could have been the best possible evidence for the prosecution to prove the threats allegedly administered by the accused and demanded of ransom. Even taking off evidence of PW1 and 3 as correct, all that is proved is that they received a phone call from someone for demanding ransom, and a person threatened to kill their son in case ransom is not paid. However, the prosecution is not able to connect the alleged demand and a threat with both the accused. Therefore, the intricacies of Section 364 of the Indian Penal Code were not proved by the prosecution, inasmuch as the prosecution failed to lead cogent evidence to establish the second part of the 364A about a threat given by the accused to cause death or harm to such person. In a given case, if the threats given to the parents or the close relatives of the kidnapped person by the accused are established, then the case can be made out that there was a reasonable apprehension that the person kidnapped may be put to death or hurt by the accused to him. However, in this case, the demand and threat by the accused have not been established by the prosecution. Therefore, the only conclusion is that the conviction to appellant for the offence punishable under 364A of the Indian Penal Code will have to be set aside.
So-
However,
Demand and threat.
that is not
Oh.
it. However, there will be a conviction for a lesser offence of kidnapping defined by Section 361 of the Indian Penal Code, which is punishable under Section 363 of the Indian Penal Code. It is not in dispute. So it was converted to.
Whether it comes under it. That is the question.
I know.
On that particular day, instead of going to school, he went to celebrate.
That we have
Yes, what I'm trying to
gone
say,
through.
Malot, yes,
Is
what-
any authority, what is kidnapping from lawful guardians? Or what is the parameter which is the
Malot, in respect of 361, I don't have. 364 A, Malot, I have. But reading 361, what is appears, Malot, that whoever takes or entices. So therefore, the first ingredient would be he should be taken away, or there should be some enticement from, Malot, from his lawful guardianship. And secondly, Malot, he must be a minor below 16 years. My lord. Any minor under 16 years of age. So the materials on record, my lord, in my humble submission, does not show, my lord, that he was taken. He voluntarily, willfully went, my lord, to the place of where they, my lord, met everybody, the accused person.
What do you mean by taking away?
In that respect, my lord, lordship is correct, my lord. Some authority would be required. But if we come to the next part, my lord, the taking
Let us
away,
assume for a moment there was no enticing for a moment.
My lord.
Either taking away or enticing from the lawful. Right?
Yes.
Enticing away, there's some kind of allurement or some hope. Right?
materials
We
does not
go
indicate.
with
Exactly.
allurement, suppose
Yes, enticement.
one,
element.
your friend
Yes,
is
yes.
not very inclined to accompany you to a cinema hall to enjoy a movie. And he will say, "Please, come, I'll order cold drinks, so, during interval." That is some kind of, okay, please, go, please accompany me. That is some kind of, that, yes, You accompany me, you'll be given food and all, cold drinks and all. That is some kind of, what is taking away? This is a broad term.
Yes, it's a legal connotation. But my lord, I'll come to that. But before that, my lord, what is required is the prosecution has to prove that the boy was, my lord, below 16. So unless this requirement, my lord, is fulfilled or met, or it is brought on record, the other part, my lord, it becomes redundant. Taking away or enticement is relevant only when it is proved, my lord, that he is below 16. Now, if your lordship see, my lord, there is no material on record except one statement of the father that he was 15 years old. Now, the prosecution did not take the pain to bring on record any document. He's a school-going student. Number two, there is no medical evidence showing that, my lord, he is at least, my lord, below 16. Now, in this regard, my lord, my respectful submission is, the lordship will take up the presumption, my lord, under 114 Evidence Act. G. Had the, my lord, evidence been brought on record, it would have gone against them. 114G. Now, in this regard, the benefit of doubt should go to the defense, because by way of cross-examination, we have challenged the age of the boy, saying that you were 17 years old. We have put a question to the father that at that point of time, the boy was 17 years old. Now, prosecution, my lord, did not bring on record any material. So this is a requirement, my lord, for, my lord, attracting the ingredients of 361, that he is below 16. This is the primary requirement in my humble submission. So benefit of doubt should go to the, my lord, accused person, the defense. And the cross-examination part, if your lordship sees, we have challenged this, the age, that you are 17 years old. If your lordship comes to page 27, 1, 2, 3, 4, 5, fifth line from the bottom, it is not a fact that I was aged more than 17 years at the time of the incident. This question was put to the boy. Indian Evidence Act, my lord. Court may presume existence of certain facts. G, my lord. The evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. That
No,
evidence is not on record.
Mr. Taluda,
Well.
merely putting a suggestion will activate the presumption under section 140. By putting a suggestion, whether you can activate the presumption under section 114C, because presumption is drawn
Right.
upon establishment of a fact.
Right.
Presumption cannot be drawn after putting a suggestion. Am I clear?
Correct.
Presumption is drawn when something is, one fact is
That's
established.
correct. It's in
Right.
a positive
Now,
manner.
have you
Yes.
established that this boy is a student and they have a certificate, but despite availability of certificate, that was not.
That depends,
The-
my lord. Has
See,
correct. Lordship is correct, my lord.
presumption has to be drawn, suppose
On
they
positive
said
fact,
in
my lord.
B,
Correct. Lordship is correct.
that the marriage was solemnized within 7, event had happened within 7 years of it. And there is second ingredient, that there was demand of dowry soon before that. Right? And the cause of death should be unnatural. Then you can presume that it's a dowry.
Lordship is correct.
Right. So merely putting a suggestion, you cannot activate a presumption. It has to be on the basis of establishment of a fact.
Positive
can
assertion, my lord. Correct.
Get the presumption operated. You can make something. I don't think 114D will be activated.
My lord, will kindly see.
Telugu,
The
when
charge,
they had the possession, they have not. This has to be said
correct. The
in
positive
specific term.
charges was under 364A. 364A says whoever is kidnapped or abducted. And their case is, my lord, he was 15 years old at that point of time. Now, no material is brought on record,
So we are considering on this.
my lord. No, what I'm trying to say, even if, my lord, that was not a case of 361 at the relevant point of time, it was a case of 364A. Now, it was incumbent on the prosecution, my lord, to bring on record to show.
Is incumbent on their
Yeah.
part.
So that not having been, my lord, established, so my
Incumbent on-
respectful submission is 361A is not effective.
that cannot be. If it is a minor and cognate offense, then court can enter into it.
The prosecution must prove it. my lord.
That is
The
what I'm
benefit
saying.
of doubt should go to us.
No, no.
This is my
That is what I am saying. We are concentrating on it. There are two things. Suppose court, you have seen many times that whether it is a case of murder or culpable homicide
Homicide.
not amounting to murder. The charge was under 304. But at the appellate stage, many an appeal,
Yes.
in many appeal.
No, it
that-
is convert.
So this power is available to the appellate
No.
court.
Appellate court has ample power.
Right. 364A, it contains three parts. One is whoever kidnapped or
Abduct.
abduct. That is 361 ingredient. In addition, there should be apprehension that death or hurt will be caused. There should be demand for ransom. These two additionally. Now, suppose we do not find that demand and threat together. In the absence, benefit of doubt to go for accused. Then what remains? Whoever kidnaps or abduct can come 361. That is what we are asking the prosecution, whether taking away or enticing away from the lawful guardianship is present or not. So you leave that part whether 364 is to be is not even converted. An imprisoned conviction under 364A cannot even be converted to 361. Legally it is permissible, but here the ingredients are not. This is what you have done. Am I clear?
Correct. My lord,
Court has the power.
Yes.
If it finds ingredients of 361 present. Now it should be on that ingredients of are not present.
my lord, in respect of that two expression, taking and
Away
enticing.
or
Yes.
enticing.
My lord, Lordship will kindly give me one more day to
We'll
place
close
some
this,
authority,
we'll
my lord.
close this.
Uh,
We'll close this.
The face of it, I don't find, my
Reflection
lord,
time was given to you.
My lord,
I don't find, my lord, ingredients of section 361 is there because the boy is about 15 years. It will go against us, but at the face of it, my lord, on his own he went off, my lord, went out with his
Find
friend.
out that famous Varadarajan case. 60s case.
Lordship, talking about as
As
Varada, yes,
case, 60s.
AR 1965 as 9 foot. As Varadaraja was state of Gujarat.
Taking has been exchanged.
There are 7.
There is not
8,
a word in the position of Savitri. Savitri was the
Yes.
from which can be drawn that he left the house of kin of her father at the instance or even a suggestion of the appellate. In fact, he can be admitted that he took her she herself believed her at 13 days, picked up that day, and finding him waiting in a car for the appellant by complying with her wishes and by no stretch of imagination her the keeping of her lawful car. Punishment. The law did not cast upon the appellant the duty of taking her back to her father's house, or even of telling her not to accompany him. She was not a child of tender years who was unable to think for herself, but was on the verge of being majority, was capable of knowing what was good and what was bad for her. She was no uneducated or unprivileged, but a senior college graduate for her time, lived in a modern city, and was thus far more capable of thinking for her and acting on her own behalf an unlettered guard getting from related. It could, however, be sufficient the prosecution established that though immediately prior to the minor leaving the father's protection, no active part was played by the he had at some earlier stage solicited or persuaded the minor to that is there is nothing in it. In our opinion, if the evidence to establish something, it would not be legitimate to infer that the accused is guilty of taking out of the keeping of the lawful guardian merely because he has actually left her guardian house or a house for her. But joined the accused helped her in her design of return to guardian's house by taking her along with him from place to place. No doubt, the part played by the accused could be regarded as the that part, in our opinion, falls short of inducement to the minor slip out of the keep of her lawful guardian. Is therefore to taking, put on. So this is considered to be a classic case for the it is
So there are two other judgments wherein this judgment has been discussed. This is one Assam case, my lord, is also there.
Moniram Hazard.
Moniram. And there is, my lord, this 73 SCC is there, my lord.
So in
Pokralal.
one case it is doubted.
Thakuralal D.
Recent,
Recent.
that is fine.
There is 73 2 SCC 413. Thakurlal.
Till 2010 or 15, it was not that much I am sure. thousand 21 CS 12 distinguished and 2000 border region was distinct, not over, distinguished on fact. Yes, what is the effect of this FIR? Can you highlight?
My lord, the first FIR is not brought on. The content, my lord, I don't know.
This FIR has been lost. This written report has been lost after recovery of document.
The consequence of the same allegation, my lord.
Where after recovered. Now, how to share it? This is a first information. Let the first information.
No. It will be, my lord,
How?
yes.
All this CT and Tony, Pura, relying
Babu.
on her. There is a fire already. And subsequent FIR is hit by one. Is it not?
But
But there is a case, GN. GDNP is not disclosing any commission of a cognizable offense. GDNP is only regarding missing of a boy. So how this FIR can be treated to? Because had the GDNP disclosed commission of cognizable offense, it would have definitely, the FIR would have definitely hit by one.
once it will,
But here in this case, how this situation is to be treated?
my lord, my submission is in respect of the same allegation. Missing of the
No,
boy.
same. Where is the same? You were silent during the entire trial that there was a written report earlier, written report regarding missing. The prosecution has only proved a GD entry, 244, dated 10/5/2024, 2000 something, 10/5. And thereafter this FIR, so you have not advanced or confronted
No cross-examination.
the prosecution with any kind of thing that there was a earlier
No, they themselves has said.
report.
No, the informant, he himself has said that he has filed an FIR.
No,
He said-
defense has to declare some burden also
He has brought on record.
to make such kind of submission. What did you do? Prosecution has said GTND 244. Then after this FIR. What did you do?
Because I lodged an Ejahar with Bizni police station on 10th. This is his specific state.
Hmm.
Informant.
No, is there any cross-examination on that aspect? Anything, any whisper that this FIR has been lodged after knowing the entire story, so it cannot be taken into consideration. Is there anything?
No, no.
Nothing. The case is to be set up by the defense also. Like you said that I questioned about the age of the victim. Did you question about the FIR? No. You have made all this story, embellishment, improvement.
I lost the retain Ejahat in the cross, my lord. Lost the retain Ejahat with the PS on 10th day of the month.
Is 44 cross exam.
Which part?
Fourth line. Immediately after the cross. I seized the mobile phone to which the call was made, but didn't find the
Up to 94 days. Not the father's mobile. Not the father's mobile. 90. Now, this mobile phone, one high-tech mobile handset, mobile hand, model number one, we don't, right? Right? And is 90. Orun Sinha, one Sony Ericsson.
It was seized on 10/5. This is the one from
Oh, no, he's not that. These are
page 96.
is 94 as well as
But with reference, there are 13/5 with reference to the GT. Not on 13/5.
mobile phones of the father.
Yeah.
Somebody else. Somebody else. Not-
First, my lord, because the SIM seized by the IO didn't have the SIM card, the mobile phone. Here with the
no,
SIM card.
let us read the content 94.
It's
I see SI is very slow. To hereby seize the following specific the positive use. One Mahadev Das, two Sanjay Das, three Ram Prasad Mishra. In connection to the above difference, in presence of the below sign, in the seizure made at number 3 is 5 2010 at 6:20 AM, right?
That was from the accused.
AQ. And also page 96. Purmani Hoikia, to hereby seize the following use by Murthy. Right? In connection with so on 13 at number 2 Bishnupur Bazaar. This is from number 2 Bishnupur Bazaar 35 2004. Now, whether this period, what he has produced as material PW
Exhibit 6 is the scissor list. It was not exhibit.
Huh?
Exhibit 6 is the scissor list, but material exhibit was not material
It
exhibit.
is the mobile handset with Arun Sinha. Exhibit 60 is my signature. Right? Exhibit A is the CTR analysis report that I collected, but that is not certified. The service provider is Aircel. There are 6 pages in Exhibit A. Exhibit 9 is the so and so. The material exhibit was not produced. The primary document was not produced. And it is also not secondary evidence in the form of 65B was not produced. So how does it we connect it? We have to discard it perhaps. All this seizure is made, but seizure has to this primary document, suppose mobile handset is produced. And there the evidence of making a call to the mobile number of the father, then the link could have been established. Neither the primary document in the form of mobile phone nor secondary evidence in the form of a certificate 65B was produced. How do we establish the link? Prosecution has not established the link. From the making a call with the and it was hell. It was not producing the certificate 65 till judgment is delivered. The curable defect be produced at any time. Yeah, that additional public components state of
Lordship, if
no, what is how it is to be treated. Will and other things I have to do that. I try to get stop it. Could not get it, so I have to.
Item number 7 from the daily list.
Item number 70.
7.
Seven. Yes.
Okay, adjourn the matter.
Okay.
A senior was praying for adjourning for 2 weeks. Apparently, they wanted to engage some senior counsel. So, my lord, may I fix a date
Lord, fix the date.
after 2 weeks.
You will not fix any date, Mr. You are for respondent.
I am for a private,
Private
response.
response.
I am for a private response. The
Is there
prayers
any
from-
stay of anything?
No, ma'am.
No, then. MS
And Sultana on behalf of Eskenazi.
M. Sultana
And Sultan
and
on behalf of Eskenazi.
Sultana Council representing MS Eskenazi has prayed for an adjournment. Mr.
A board.
Ebur, Mr. B.P. Kukui, Senate Council. And additional public prosecutor for the response number 1. Mr. Ebur, Senate Council for the response number 2. As a clear vote by the chair. No stay, sure.
May it please your lordship. Lordship,
Hmm.
quoted in application, Lordship. After
FIR?
is page 10. Killing of a pet dog, my lord, from the residence of the foreman, my lord. 25 days it has.
Who were arrested?
But the 3 persons got arrested, my lord. I'm Robinson Inky.
On the basis of CCTV footage.
Lord, the vehicle image was seen in the CCTV footage. Vehicle's image. But the
Vehicle's image.
25 days in custody.
Huh?
25 days in
Oh.
custody.
You were what? Owner of the vehicle?
No, I was the occupant.
Occupant.
No, I was arrested in a different place. After 2 days,
The FIR is just there, but it was taken away.
second.
Yes, that purpose would be served.
They admitted forwarding that
Hired Mr. T. Kolita and and we're not calling for case diary. And Mr. B.P. Kukui learned. How many days?
25 days. 6/4 was the forwarding date.
6/4.
6/4.
How many days? Then?
20
Days what?
25.
25.
25 days.
Yeah, the first information report was sought. Report of danger was sought by 9. With the allegation that his pet dog was lifted at around 5:48 on 2/4/2020 by unknown miscreant. From the CCTV footage installed at his premise, the informant got that the pet dog was lifted by the driver and the occupant of a vehicle bearing registration number AS 09 A 1776 RD. Para in the course of investigation, the accused person, including the accused petition, were arrested based on the footage of the CCTV installed in the premises of the informant. So, after arrest, the accused persons were produced before the court of Chief Judicial Magistrate Mongolway on 6/4/2024, and since then, the petitioner in the submitted by the letter, but I since the main evidence as regards the alleged theft, alleged offense of theft to be just and the same has already been collected, the release of the accused on paid. There is no further necessity. There is no necessity for further detention as uh, it may be as of the name of the ticket made in a head of on the side as uh, it appears from the fire and the verdict is to be based on wisdom. Having regard to the nature belief, considering the fact that many the fact and considering the fact for near 55 6 months there is no further detention of accused is or further activity the expect operation rate at the near
Dorong,
Lorong
Mongol. There is no FIR, my lord. I have narrated my facts in page 3, paragraph 3. May I?
you've been called to the
Yes, I have appeared once, but thereafter regularly visiting my.
you have one
Yes.
yes Mr. Gogoi
It may be take up at 2, my lord. We will take steps. Tomorrow.
Are Mr. NJ Dr. Uh, uh, by submitting on the petition has ever that he has been repeated call to the Tipajar police station since the first week of April. In connection with certain allegations apprehending arrest or petitioner stated that he has once appeared before police, but to his knowledge, there is no FIR registered against him in the state. Mr. Gogoi and has got listing of the case, has submitted that you obtain instruction as to whether any case has been registered or not at Tipajar police. As sought for by Mr. Gogoi, is the case tomorrow.
I'm okay.
Material for 30th Philip Dixon Road to FIS page number 10.
Here.
May I read the sir, most especially submitted the above named second party of number 1 and 2, which the associated Ratunath and Mikalidas opened accounts for the money of the well-known persons in the business establishment, namely Assam Gaolia Nidhi Limited, stating that the same was government employment establishment, and even after completion is declared to the state amount were not returned to the undersigned, while showing various excuses and they are obtaining from the payment and the second party announced only.
So your CEO has got the interim bail.
Yes, sir.
Yes. Employee
Yes.
already sent an interim bail to the CEO, so-called page
19.
Next. Yeah.
22/5.
Yes, sir.
Heard Mr. P. Dotto, current counsel for the petitioner, and Mr. P. Gogoi. In the first 24, the petitioner is named along is named as an accused along with one, three, Pulin Soy. Four. The petitioner has averred that he has been appointed as an to promote as assistant branch manager of Hong Gaolia in Nilim. I can take a completion of the government consistency of our bill bond. Same.
There are two petitioners before your law. husband and wife. Number, although there is no allegation against petitioner number one, but my lord, name is included in the FIR, my lord, I before your lordship. Page 16 is the FIR, my
Hmm.
lordship kindly see
Yes.
that
Yeah, put me-
petition number 2 was awarded with a contract match, and due to his personal engagement, he gave a one power of attorney to the complaint to complete the work. But he unable to complete the work. Ultimately, I have to complete the work, and I issue a notice to cancel the power of attorney. I issue notice to the power of attorney, and after they giving reply to my legal notice also, and thereafter file this FIR. But from the plain reading of the FIR, it is crystal clear as all are my lord civil dispute matter. And there is no ingredient section 420 and my lord 406. The lordship go by my lord.
You are who petitioner number 2 is contractor or what?
He's a registered contractor, my lord. I have given the slip of yes, registered contractor, my lord.
Registered contractor
Yes, Annex 3, page 20, my lord.
is
Yes.
20.
Page 20. Registration certificate is there.
Class 2.
Class 2, my lord. That is the Annex 4, page 21 is the award, contact award, my lord. That is the agreement. And then, my lord,
What is the
allegation that, my lord, I giving her power, giving the complainant to power of attorney to complete the work. And now, my lord, he unable to complete the work. I have to complete the work, and I got the money. And now he says that the money has not given to me. The power of attorney holder says that no
Right.
money has been given.
Yes.
Yes, that monetary.
On a state of put her two petitions. Period. Connection. Summary petition is under 20 registered for of photo. The first information is lost by one Mr. Vidal 12 4 2024 was has been registered on 19/4/2000.
My-
In the FI, comma, the informant has stated that in respect of a contract work, comma, the petitioner number 2 has given a power of attorney to the informant to execute the contract, which at a contract price of 47 47,480. So, as per the power of attorney, comma, the was empowered to execute the contract for
Work.
and to submit bills and to withdraw
No, we
the bill amount from the employer, that is the public works department, government. So the informant has inter alia alleged that without his knowledge and consent, the petitioner number 2 had fraudulently withdrawn the bill amount and was not receiving, was not maintaining, was not maintaining any kind of communication with him transport fare. The petitioner number 1 is an employee of All India Radio,
my lord, all India.
and the petitioner number 2 is a registered class 2 contractor, is a class 2 contractor registered with the Public Works Department, government officer. The petition number 1 is the husband of the Mr. Conto, and preparing for the petition. There is no allegation in the affair. There is no allegation against the petition number 1 in the affair. No specifically. So, insofar as the contract work is concerned, it is the petition number 2 who has been given the contract work. And after execution of a contract agreement on 6/5/2000, though the informant was given power of attorney by the petition number 2 to execute the contract work because of some other engagement of the petition number 2. The informant did not proceed to execute the contract work to stop. In view of non-execution of the contract work by the informant in a manner
Issued a legal
mentioned in the power of attorney, the petition number 2 had to issue a notice on legal notice
Legal
on
notice.
8/2/2024 to the informant requesting not to use
power of
the power of attorney anymore in respect of the contract.
and he has given a reply also.
Uh,
He says that due to unavailable circumstance, I am unable to do the work.
Okay. A reply to the state local legal notice
Page 30.
was also furnished, was also sent by the informant stating failure therein, that due to
The word used unforeseen circumstance.
which
Page
page
31, first line. Page 31, first
due
line.
to unforeseen circumstances beyond his control, he could not proceed to execute the contract to
Complete the,
complete the to the
and thereafter he lost the.
from the documents annexed to the instant application, it is noticed that a contract agreement in respect of the contract in question, was executed between the petition number 2 and the Public Works Department of the the informant was admittedly given a special power of attorney to execute the contract for was given on
26/5/2020.
26/5/2000. Next third,
Next up, 5/8/20.
next third, 5/20. From the legal notice dated 8/4/2024, it appears that the informant was requested by the petition number 2 not to use the special power of attorney in respect of the contract for from the on and from the state date. A reply was also sent by the informant informant within bracket number 8 on 15/2015, wherein he stated that due to unfortunate circumstances, he could not complete the contract for the manner having regard to the nature of it. And it applied and facts emerged that the dispute between the informant and the petitioner have arisen out of the contract working common have made out for accordingly 25,000
Mal.
one security
Ujinawi.
satisfaction to the testing authority 10 days IO
20,
Diploma.
205.
2005 22 for production. Yes, sir.
Diploma.
Well, 438 application, two petitioners, both are father and son. Case registered under 379. But you will find the FIR at case 13. Married.
Hmm.
13. There are five accused persons.
Hmm.
Serial number 4 and 5 is the present petitioner.
Case 13.
Yes,
Okay.
one female.
Hmm.
Five accused persons are here. Accused number 4 and 5 is the present petitioner.
Okay.
সন্মানপূর্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 8 তাৰিখ 2024 ইংৰাজী তাৰিখে ৰাতিপুৱা 8 বজাত মই দলেৰ পথাৰ হাফিজিয়া মাদ্ৰাছাৰ ভিতৰৰ বেৰৰ কাষত মোৰ চাইকেলখন থৈ কামৰ বাবে বাহিৰলৈ ওলাই যাওঁ। আবেলি মই 4টামান বজাত ঘূৰি আহি দেখা পাওঁ যে মোৰ চাইকেলখন কোনো অজ্ঞাত চোৰে চুৰ কৰি লয়। পিছত ঘটনা সংক্ৰান্তে পুলিচক খবৰ দিয়াত পুলিচে ৰাতি 9:30মান বজাত উপস্থিত হৈ স্থানীয় লোকৰ সহযোগত দলেৰ পথাৰ হাফিজিয়া মাদ্ৰাছাৰ CCTV ফুটেজ চেক কৰাত উপৰোক্ত আসামী জেকিবুল, তানিতুল আৰু দিলদাৰক ৰাইজে কৰায়ত্ব কৰি সোধপোছ কৰাত চাইকেল আৰু খেতিপথাৰত থকা 3টা মটৰ পাম্প চুৰ কৰা বুলি স্বীকাৰ কৰে আৰু সিহঁতৰ লগত ইমদাদুল আহমেদ থকা বুলি স্বীকাৰ কৰে। That is the malot on accused number 5. So malot only that line is against Imdadul.
Why father is impregnating?
No, my lord, actually, lot will
Huh?
find the seizure list, my lord. All articles is seized, my lord, from other.
Why?
So-
Why the father Hazrat Ali is apprehending?
My lord, his name is there, my lord. I don't know. my
Okay.
lord.
Imdadul,
name is
like
there.
Imdadul, something is there.
But
Who accused-
Hazrat is also named.
Yes,
Regarding
his
Hazrat,
name.
Heard something
Hazrat,
provide.
Hazrat,
He has been named without
in FIR name, but
in the FIR he has been named
Yes.
without any allegation. And Imdad, they have said that he is involved.
who
But
accused
he was not, there was no overt act on his part.
Yeah.
Imdad. Maybe
that CCTV, that
CCTV?
People.
that may be indeed died.
CCTV footage Zekibul Sanidul Dildar.
3%.
Heard anti-political petitioner. The Ishtama one is the father of the petitioner. In the FIR. 24, the informant has alleged that on at around 8 a.m. on 8/4/2000, his bicycle was stolen from inside the premises of a madrasa. When the police was informed, 3 persons were apprehended on the basis of footage of the CCTV installed in the premise, and according in the FIR, but according to the informant, the 3 apprehended accused persons confessed about the fact of theft. The 2 petitioners are also named in the FIR. 2 petitioners are also named in the FIR as accused persons besides the 3 apprehended accused persons, and in the FIR, it was alleged that the petition number 2 was involved. No, the apprehended 3 accused persons confessed that the petition number 2 was also involved in the act of theft. Though the petition number 1 is named in the FIR, no overt act. Though the 2 petitions are named in the FIR, no overt act of theft, no overt act on their part in the commission of the alleged theft was mentioned in the provided COD before the IO 10. Take 25 20 will sit after 10 minutes past 2. 8. Eight is the FIR lordship. Actually, the only non-bailable section is 379. Other than lordship knows it's bailable. There is a shuffle. So verbal favor passers by. There was a rash and negligent driving by the JCB driver. And after the cheating portion is accessory. What is stolen?
There is no specific allegation against anybody. Allegations are generalized. That
Yes, Mr.
Lordship, yesterday one of the co-accused have granted bail by the honorable.
in
Uh,
other court, not by
Oh,
by a different lawyer.
support. There I have fixed the, I was there. Case there was fixed for. You have the order there.
Ordered for
There
There are 5 accused in lordship. Accused number
he
3.
was granted interim lordship and the CD was fixed for 35.
Hard. Mr. SM. Current counsel of the and able
Look.
grant additional to be period or or it works of Dolport collision fight etc. of the Dolport are affected. Okay. The driver of the SUV across the SUV and 7 to 8 people and the key of the SUV vehicle and the mobile phone of the driver and to live with the current transport. There was and there was some stuff but no snitching or assault. No incidents of snitching assault. Further considered that one of the accused, namely
Accused number 3.
already extended the benefit of interim stay by an order dated
29-4.
29/4/2020 passed in AB
AP number 111 2 112/20.
is for production of lead on 35.
35. 305.
3005. Having regard to the application, 25,000. How much?
50,000.
50,000. One Indians.
Obliged. Made please, Your Lordship. It is a 439 application, Your Lordship. Actually, the petitioner here was soon arrested. He was earlier arrested in a different case. In that case, he has been granted bail by this honorable court.
Yes, it appears to be an organized crime,
Organized crime, my lord.
cyber crime.
Yes, that present
Uh,
petitioner, he has a, my lord, mobile repairing shop. And that business method, my lord. But he is not directly named. Informant is that about 10 crore 73 lakhs 58,300.
It is an organized crime,
Yes, yes.
cyber crime. All with the computer. Now, what is it?
Is his rule.
But it is role. Right?
It, I, I, I have not found any direct maladies involvement. Informant and other forwarding everything I like mark method. Informant statement.
Pretty much here I am soon arrested because I was arrested in a similar type of case earlier.
He named anywhere because I am not conversant with this kind of thing.
I also do not know matter that technology, but here that which company file lost this FIR matter, this statement is there to informant matter, I have flag mark matter.
The informant will not be able to tell anything.
Yes, yes.
This from the FI itself, it is clear how it is wiped out. Money is totally appropriate. Question is, what things have unearthed during a court? Cybercrime, you may not, person may be sitting in America doing all these things. Question is, how much you have unearthed about his involvement in the crime. Is there
My
evidence?
lord, that
Please go.
investigation is going on, my lord.
Huh?
Investigation is going on.
How his involvement is, why he is arrested? Any antecedent?
Forwarding shows that, my lord, he might be that type of, my lord, forward.
The amount involved is quite huge, but
Yes.
the concerned accused person should be arrested. At the same time, one who is not involved, he should not be arrested randomly.
Because earlier he was arrested in a similar case, my lord. So
That
here
does not
shown
mean
arrest. That is the forwarding.
was he in league with the other accused person?
He knows some person.
Any money is
No, my,
got credited into his account.
no, my lord. And already,
That
my
is
lord,
not reflected.
49 days in custody.
No, we are not in such type of cases. We are not
Not to be correct, but
such a huge organized crime.
it's an organized crime.
Here
If
we
he
are
is
not
involved in-
concerned with custody. He is involved in the siphoning of 10 crores, 15 crores, no lady. Question is, where he is involved.
Got-
Here forwarding showing one reason, my lord. During investigation, it is learned that a total number of 148 numbers of transactions were made using the Paytm ID number so and so linked with mobile number so and transaction of rupees 8,36,235 was made, which was later misreported by accused person.
Yes, sir, go ahead.
Proceed.
Yellow. Is it the same man? Yellow one. Name is same.
But there are two Ikram.
That is why
He was
the
at
money landed up in his account, the name of one Ramul. Seven have been identified.
That mobile number is that mobile number matter to
That is different. That is
no, there is another
no that may be that mobile number 9678202260. That is mobile.
you are the beneficiary. Money landed up in your account out of all those fraudulent transactions.
as per my instruction, your lordship, there was another Ikram, and his name is same.
So,
I have annexed his forwarding report.
This is your forwarding.
Annex of 4, page 29. Page 29 to Beleg Ikram. It's Beleg
Huh?
Ikram. Muno.
Why we have an
It's annex the fact that Arota Ikram. But this is a different Ikram.
son of Nur Rahman?
no, in your forward, where is your forwarding report?
My forwarding report is at Annex 3. Page
Next
13.
page
13.
Page?
Page 13.
13,
26.
page 20.
26.
26.
Your
Six.
father's name is Ahmed Ali.
Huh?
It to Beleg.
His father's name is Ahmed Ali. That Ikramul's father name is my daughter Nur Rahman. Same name.
No, no, it is not named.
Yeah.
No, where is his mobile number?
Mobile number that page 30, my lord, that wording of Nur, son of Nur Rahman, not present petitioner. I thought that the same name, my lord, is important. Ikramul Haq,
And is there any Ikramul Islam? What is this? Where is your forwarding report? 26.
My forwarding report is a page
26. Let's see.
26.
28 is my name.
So you are Ikramul Haq, son of Ahmed Ali.
986481. That number is correct.
Yeah, the other one,
Yes, another
blue one.
other 9864812343.
Telling. Have you disputed anything about your mobile number?
Manoj,
Anything?
no. We have disputed that we are not
Right.
at Ikram.
But other one,
We are not at
father's
Ikram.
name was also only mobile number
Manoj,
One,
that mobile
three.
number,
43.
we have
Yes.
He is also one of the money landed up in his account out of 10. Mobile number is telling with the forwarding.
Lordship, the mobile number might tell him, Manoj, it may be hacked also.
No, no. Money landed up. Okay. The organized crime. This is not snatching away mobile or something like that. It is very well organized
Lordship is correct.
crime. It is cyber crime and it has the effect of affecting the nation also. Road building.
may not it may
Alright.
come up next week.
Art, that is why I have checked.
But
Alright,
it may come
Mr.
up next week. or not.
S.M. Abdul. But I have formed an opinion. This is our hard. Mr. S.M. Abdul Council for Diabetes petition, and Mr. B.B. Ghosh learned petition of 413. The accused petitioner was shown arrested in connection with PIO police station case number 5 of 2021 when he was in custody in connection with another matter. The first information report was lodged by on behalf of MobiQuick, a company involved in providing mobile wallet service. The company, MobiQuick Systems Limited has been associated with the National Payments Corporation of India for developing National Electronic Toll Collection Program. The company is further is is- has been given a task to implement Fast FAS AZ small FAST capital AZ program in India by the Indian Highway Management Company Limited, a company promoted by the National Highway Authority of India. From the contents of the affair, it transpires that 30,938 illegal transactions were made by 29,758 distinct customers in the state of Assam, involving an amount of rupees 10 crore 73 lakh 58,331 within bracket approx. The state amount was for FASTag, the company in the affair, as mentioned, that the state amount of rupees 10 crores was utilized for FASTag recharges for 617 vehicles. On analysis of the transaction, the company found out that the customers in the state of Assam had recalled in repaying the amount utilized to recharge their FASTag through GIP product. As the company alleged involvement of a big racket and sought for an investigation. Accordingly, the FIR was registered. In the course of investigation, a number of persons were arrested, and petitioner is one of the accused persons who has been shown arrested in connection with the rape case on and from 13/3/2020. Mr. Gogoi learned has produced the case that from the case that it is noticed that the it is a case of organized cyber crime. The materials in the case that from the materials in the case that it appears that out of till 29,007 distinct customers borrowed got loan from the informant, that is Quick System Limited, to 30,000 in the name of recharging assets against 707 number of amounting to a loan amount of 8 crores 7 lakh 85 lended was lended in total 6 customers on further analysis of the data provided by with respect to the aspect of 7 was found out that amount were lended up in at least accounts of 7 number of persons. The petitioner here, who is shown to be holding mobile number
Page 27.
nine eight six four eight 123 43, comma, is one of the 7 persons in whose account amount out of rupees 10 lakh, part of the amount, part of the amount of 8 got transferred and linkage amount
Apply.
accord. I'll put it over. Yes, sir.
Yes.
All these technical terms not find it difficult. I have dictated from the case there only. Is there received?
No. That is the-
That's it, submitted.
Search is submitted better. Preferred application there.
My lord, I may be allowed.
Against him?
Lot.
Against him?
Against 5 lordship,
Five.
5 and 1 is absconded.
So the certificate is submitted. I may be allowed bail from. my lord.
Preferred
I will-
application there. Because there is no case diary here.
Even my lord,
Heard
health
Mr.
of
A.K.
the,
Azad Learned Counsel for the petition. We tried to call the case there at the earliest, Mr. Azad. And MS A. Begum learned petition public. MS Begum learned additional public prosecutor has submitted, instruction, that after completion of investigation in connection with Mukhalpur Police Station case number 33/2024, IO of the case has already submitted a charge sheet under section 173(2) CRPC by charge sheet number
Case number 22/24 dated 24/4/24.
finding a crime is well established against the accused, succeeded accused person, which includes the present accused. So, in view of the same, the incident in stands closed, reserving the liberty to the petitioner to approach the learned jurisdictional trial court for his release on bail. So, it is further observed that even the petitioner approaches the learned jurisdictional trial court, consider the petitioner's application for bail on its own in an expeditious. Yes, but in
Wait.
the case,
Wait, your lord.
it has already
This matter,
filed.
the petitioner has filed an affidavit today. Most probably it has not come to the report. Therefore, Lord,
Nothing is there. What is the case about?
it filed today, Lord.
What is the case about?
This is the passing petition, Lord.
You file objection or what?
yes, yes, we have filed a- against that objective petition, they have filed a reply. That is not
Objection petition. Where is it? Big one or small one? Your objection.
medium.
Find out then. Is there or not? In the previous order, it has been recorded the CBI has filed an objection. Whether it is there. Neither objection is there nor your reply is there. Okay. Registry has to trace out your file.
Yes.
Heard Mr. R.P. Listed by Mr. Sudhar.
Special,
Yeah.
special people or retainer.
Special public prosecutor. Special public prosecutor.
Yes.
CBI. For the respondent number
3 and
3 and 4. Mr. S. Bothakur, Learned Counsel, representing Mr. S.S. Roy, Learned Standing Counsel. Learned Counsel for response number 5, 6, and
45 for response number 1, 3, and 1 is CPS,
1,
3 and 4.
3, and Mr. Gugoi, you are for Assam, Home Department. Gugoi, BB Gugoi, Additional Public Prosecutor 2 M. Halloi, Learned Special Public Prosecutor and CBI 1, 3, 4. As Portacourt representing SS Roy, Learned Counsel for response number 5, 6, and 7. Mr. Halloi, Learned has submitted that an objection to the an objection on behalf of the respondent here. Authority has already been filed, but the same is not checked the case. Has already been filed. File document number 6/2000.
State of filing, file the notice.
Filing is filed. So keeping that a reply to the state objection has also been filed today.
Today.
Office, the office shall get out the objection filed on behalf of the respondent CPA authorities as well as the reply filed on behalf of the petitioner today, and thereafter and to take the same with a case like this after a week.
It's a date is got
After a week, only date to be. Any interim order operating
No, my lord.
in a clear case, Mr. Kakoti? Yes, madam.
There's a 482 petition, my lord, of the FIR. My lord, the FIR was lodged in the year 2000, going to be now 9 years, 4 months. No charge sheet has been filed.
Now, last occasion, we were directed to take action. Now, charge is submitted, 9/4/24, charge is submitted.
My lord, my simple argument is I have a plethora of judgments which says that they have to explicitly explain why there was a delay of 9 because because the petitioner here has repeatedly been subjected to harassment, to loss of opportunity for non-filing of the.
Now, non-filing, is there any laid down rule
No, my lord.
in all these judgments that
But my lord, they
if,
have to.
if the charge sheet is not submitted within a period of so and so years, that investigations will stand fast.
My lord, I'm not on that. My lord, I'm on the already established rule. There's
Now,
one from,
during the pendency, the charge sheet has been submitted.
but my lord, why
Right.
did they take
Now, question is,
9 years?
now, Mr. Gugoi, in the charge sheet, whether this petitioner is
And by this petition, they challenge the FIR.
no, that's asking for an information
Yeah.
that in the charge sheet so submitted, whether this petitioner has been charged. See,
Then we
if
may talk
this
more-
answer is in the
Yes, yes.
negative, then it ends.
Yes.
Right? That is one simple answer to all your anxiety. So that can be found. Get the information.
Yes.
First, if he is solicited, then further question will arise. If he is not solicited, it appears,
Yes, my lord.
where is the FIR?
Where is it? Page number 12, page number 14, my lord. The type copy.
Now, the specific allegation against the petitioner is that,
Other
see, that the vehicle
was found in his
was recovered from the residential compound of the petitioner. The two main accused are John Samuel Barla and Binod Barla, right? So, suppose page 19. Page 19. See, page 19. His rejection order. Third paragraph. Allegation made in the FIR is relating to theft of vehicle belonging to the brother-in-law of the informant. Materials in the case diary disclosed that the vehicle was recovered from the residential compound of the petitioner. The two main accused are John Samuel Barla and Binod Barla. Now, question is, charge sheet can be submitted against all three, or can be submitted against only John Samuel Barla and Binod Barla? If petitioner is not solicited, end of the matter. Let him get the information.
Tomorrow, day after,
Third MS as the Friday.
Yes. Agree.
As the Senate
practice
counsel for the petitioner
103.
and Mr. B.B. Gogoi, Senate petitioner for the respondent state of Assam. Mr. Gogoi, Senate petitioner for submitted that he will obtain instruct as against whom the charge sheet in connection with Sanmari Police Station case number 433/2014 has been submitted on
9/4/24.
9/4/2000.
Cited number 103/24.
Number 103. Huh? Please the case for yes.
IA Hazarika will argue this case. He was there, but due to some difficulty he left.
Yes, madam, you are for whom?
B Tech.
Huh?
London Council B Tech.
He is also not here.
Not
Okay.
given.
Mr.
I
I.
My name is
Chaudhary,
not there.
Learned Counsel, appearing for Mr. I. Hazarika, Learned Counsel for the appellant. And MS
Sir, NP
NT
Manpur.
Marlow,
Manpur. MANPOO.
PWN. Learned Counsel appearing for Mr.
B Tech.
B. Reka, Learned Counsel for the respond number. B. Reka. Okay, learn for the respondent number. Oh, this is private. What? Okay, 1, 2, 3. I have conjointly not have made a prayer for it. If you have the prayer so many come up. Like it. Then adjourn for it. Why state is not a party? Okay. Okay. Mr. B.B. Goyal and additional for the one of board state. Well, offense
498 days. Learned certificate for 1 year.
official. You are on bail, perhaps. You are on bail.
No.
You are
No.
not appeal. What is the
No, Lord, I am informant, complaint,
Appeal against acquittal.
Lordship. The learned CGM convicted for 1 year. Thereafter, they filed appeal before Supreme
Reversed.
Court.